Yo guys, you ain't gonna believe it. There's a new legal trial and I'm watching the clock because that's when the judge hears Diddy's post-trial push, a bid to toss the two Mann Act counts or rerun the case. It's set in SDNY 500 Pearl Street under Judge Arun Subramanian. A hearing isn't a win, it's a microphone. The defense gets time to argue, and the judge decides how much of that survives the law. And yes, the timing is tight for a reason. This lands days before the October 3rd sentencing, which keeps pressure high and options open. It's strategic, not random. The court didn't rubber stamp anything, it simply put the arguments on the calendar. Now the question is what they plan to sell in that room, and how hard the government plans to swat it down. Here's the clean version. The judge set a post-trial motions hearing. The defense wants acquittal on the two Mann Act counts or a new trial. It's slated for Thursday, September 25th, 11 a.m. at 500 Pearl Street, SDNY. A hearing like this isn't a scoreboard change. It's a chance to argue in open court before the judge rules. Think spotlight, not victory lap. Why it matters. The paperwork behind this date is heavy. The defense already filed to toss the convictions or rerun the case. Prosecutors answered with a blunt deny it and asked the court to do it quickly, so the 25th isn't random. It's the collision point for two briefs that don't agree on anything, including what the word prostitution meant in 1910. And yes, this lands days before the October 3rd sentencing, which keeps pressure sky high while the judge hears them out. If the motion gets denied, we march straight to sentencing. If anything gets traction, the next week looks very different. Here's their lane. Redefine prostitution. I'm not kidding. The filing says the court used a modern meaning, not the 1910 meaning baked into the original Mann Act. Their pitch, no commercial sex, adults only, travel is voluntary, so the statute doesn't fit. If the law meant something narrower back then, they say, these two counts shouldn't stand now. They stack a second card, speech and privacy. The defense calls some of this amateur pornography, recorded for private use, and argues you can't criminalize someone for filming consensual adult performances. That folds into their ask, judgment of acquittal, or if not, a new trial because the jury saw prejudicial stuff that didn't belong in a case about two transportation counts. It's bold, it's technical, and it only has to convince one person in that room. And what prosecutors fire back with next is even sharper. The government didn't blink. Prosecutors told the judge to reject the defense request for an acquittal or new trial and to do it quickly. Their bottom line, the jury had enough evidence the two Mann Act counts stand, and nothing in the defense brief changes the law or the facts. Here's the friction point. The defense wants to narrow what prostitution meant back in 1910 and recast the recordings as private amateur content. Prosecutors answer with the record the jury saw, testimony, travel, transactions, and rulings that already allowed the 2016 hotel video into evidence as relevant despite defense protests about prejudice. The court admitted it, the jury weighed it. That's the hill the government is defending. So on September 25th, we'll hear two languages in one room. The defense speaking dictionary and First Amendment, the prosecution speaking verdict and evidentiary rulings. And the clock behind all of this is still October 3rd when sentencing is set unless the judge blows up the schedule. Here's the pressure point I'm watching. Sentencing is set for October 3rd. Bail denied again, so he stays locked in at the Metropolitan Detention Center in Brooklyn while lawyers swing for one last reversal. Reports say prosecutors are eyeing a term in the 4 to 5 year range, though they've hinted it could go higher. If the judge denies the September 25th bid, we walk straight into that October 3rd date with no safety net. There's noise about the prosecution team changing. Some say Maureen Comey isn't on this case anymore, and the rumor mill spins wild reasons for it. I'm not chasing that. What matters in court is the record, not the headlines. The U.S. Attorney's Office doesn't fold because one name rotates out. Briefs are filed, evidence is in, and the judge already ruled on what the jury could see. Will the defense try to point at the switch and say the government looks softer now? Of course. Optics are a play. They'll hint at instability, maybe even argue that earlier calls were biased or sloppy. But when you strip away the drama, the judge is grading law and facts, not press releases. The team at the table can change, the rulings don't. Still, perception leaks into the hallway. If the defense walks in with a tight dictionary argument and a stack of case cites, and the government shows up with a new face, some people will read that as momentum. It isn't unless the law backs it. And that's the part the cameras can't spin. And what happens in the room on the 25th could come down to one more variable: who shows up and how they play it. If he shows up on the 25th, that's not theater, it's strategy. You stand 10 feet from the judge and send one message: I'm not hiding. Defense teams love that. They want the eye contact, the nods, the I get it face. Will it move the law? Number. But it can soften how the judge hears the same words he's read on paper a dozen times. I've seen this play before. You arrive early, you look steady, no smirk, no stare down. You accept the hits and answer clean. The goal isn't to win hearts, it's to avoid flashing red flags, ego, blame shifting, or that weird poor me energy that sinks credibility fast. And keep in mind, optics cut both ways. If the defense leans too hard on sympathy, it reads like a stall. If the government walks in crisp, anchored to evidence and rulings, sympathy shrinks. In that room, posture helps, but paper rules. The best look is boring, prepared, calm, and ready for tough questions. But that isn't the last lever in play. What lands on the docket right before the hearing could set the tone for everything that follows. Here's my checklist going into the 25th. First, the paper drops. Sentencing memos from both sides are due late September, and those filings can color the room even if they're not the main event. If the government pushes a harder range and the defense argues the law was misread, the judge will be reading tone as much as math. Reuters second, the dictionary fight. The defense wants the court to read prostitution the way Congress would have read it in 1910, narrower, more transactional, and not what the jury just convicted on. If that framing sticks, the counts wobble. If it doesn't, the verdict stands tall. Expect tight questions on statutory meaning and how the jury instructions map to that meaning. Third, the optics versus law balance. If he's in the room, the posture is deliberate, steady, contrite. None of the I'm the exception energy that judges hate. Does presence move the needle? Barely. But right before October 3rd, every signal gets read twice. Possible outcomes? Most likely, the judge denies the motion and we roll straight into sentencing on October 3rd. Less likely, he takes it under advisement and rules fast, still keeping the October 3rd date. Long shot, a new trial or judgment of acquittal. Rare, but not impossible, which is why this hearing exists at all. Either way, the stage is locked. September 25th at 11 a.m., 500 Pearl Street. October 3rd is the cliff right after, and what happens between those two dates decides whether this story fades or starts all over again.